Okay, guys, we're doing now page 22 of the study guide. We're going to go through all the clauses and amendments and right to privacy. We do this at a faster pace when it comes to final exams because he's already gone over it with part one or exam one material. And so we really hit a lot of the key elements of it. But I tend to go a little bit slower during chapters 1 through 4. Anyway, page 22 of your study guide. If you look at page 22 of your study guide, it talks about the three governmental functions set out by the Constitution of the legislative, executive, and the judicial, and how the legislative makes the law, executive branch interprets and enforces the law, and judicial branch interprets and applies the law. And it can be done with stare decisis and/or judicial review when it comes to judicial. All right, and it also creates the highest court. Supreme Court is in Article 3. All right. Next thing you need to know is cases. We're going to go over all the cases that are, and it may be a quick synopsis because I gave you a 2-page synopsis of every single case. There's a tier 1 or tier 2 in the packet. And I'm not sure if that is the red packet. Let me check and see. It is the red packet that has a page and 2/3 of all the tier 1 and tier 2 cases for finals. And it has a quiz on it as well. And then there's 30 questions on just cases in the red packet. All right. If you look over the Immigration Service and Naturalization Services shot at tier 3, you haven't heard about that one being on the exam. That was a legislative veto, not a presidential veto, but it was found to be unconstitutional. The first one that we have after Marbury versus Madison that we talked about in the earlier one is Youngstown Steel & Tube versus Sawyer. Sawyer was then Secretary of Commerce under Truman. Truman had decided through an executive order based upon his power as commander-in-chief that he was going to use a steel that was necessary during this time period and said, hey, I don't care if y'all have a labor dispute right now, we're going to keep the steel mill open. And against the wishes of the union or the mill owners, the owners obeyed under protest the executive order. They then sued Sawyer, his Secretary of Commerce. The Supreme Court ruled that the executive order created by Truman was illegal, was not within the constitutional powers that the president had. So would this be an example of judicial review? Is this the courts, through its decision-making in this Youngstown Steel & Tube versus Sawyer case, was this an example where the courts declared an action by the president or Congress as unconstitutional? And the answer is yes. They found the action by the president, in this case Truman, unconstitutional. So this question has a bunch of different things that over the course of the semester you might want to note. Remember, there's a collective bargaining agreement, so you got chapter 8 in there with labor law. Then you have executive order by Truman. Truman also has an executive order integrating the military in 1948 as well. The action was found to be illegal, thus it was an example of judicial review being utilized. This is a tier 2 case I would note for the test. All right. There are other things in the Constitution that deal with, like the Supremacy Clause, the Necessary and Proper Clause, and the Commerce Clause, and these are big ones found in Article 1 of the Constitution. Most of these are found in Section 8 of Article 1, but the first one that we have is Commerce Clause. And when we were first going over this for Exam 1, this is one of the first ones I hit and said, here's a lot of the A and B, but not C, C and A, but not B type questions that you might have. One of the things that the Commerce Clause does, it's one of the most important powers in the Constitution as it relates to business and business activity and economic activity for the most part. It gives Congress shall have the power to regulate commerce with foreign nations and among the several states, includes Indian tribes as well. If he said that in class, it's very liberally construed. Now, this is also, if you look on B1A on the semi-top of page 24 of your study guide, it says one of the enumerated powers. And this is where I said, this is where these little things that come into play from the study guide are actual multiple choice answers. And then if you have A and B or B and C, but not A, you need to note that. And a lot of people are not used to that on exam 1. So hopefully now you're used to his exams and you understand what we're talking about. The Commerce Clause gives the legislative branch, which is Congress, the power to regulate commerce with foreign nation, business with foreign nation, and among the several states. So it would be international business, i.e. global, that'd be chapter 15 and 16 if you're in 211, and among the several states, anything that crosses over the borders of various states. It is also one of the enumerated powers found within the Constitution under Article 1, Section 8. So they ask you the Commerce Clause is a part of, it's not a part of the Bill of Rights, it's a part of Article 1, Section 8 as an enumerated power as well, and gives Congress or the legislative branch the power to regulate commerce. Cases that involve this is Gibbons versus Ogden. Gibbons versus Ogden, we had the Hudson River between New York and New Jersey, and New York had decided we're going to have a granting of license for boats that are going to travel on this Hudson River. So if you're crossing over from New York to New Jersey or going from New Jersey to New York, you need to get a state license from New York. Well, the problem is that this this steamboat right monopolistic requirement to get this license to do so was affecting interstate commerce, crossing over state boundaries. And thus Gibbons appealed the court order because the court order was stopping him from using the boat without the license. Case goes all the way to the Supreme Court, and the court basically, under John Marshall, Chief Justice's decision, said there's a basic distinction between intrastate within the state and interstate amongst the states. If it's amongst the states, then among the various states, i.e. interstate commerce, more than one state, then that should be under the guidelines of Congress, the legislative branch, under the Commerce Clause. If it is intrastate within a state, then yes, the courts can grant a license or something like that. So if this river, this Hudson River, had not been between New Jersey and New York and just a river in New York, and then they need a state license in order to use it, that would be fine because it's intrastate within the state. State has jurisdiction over that. But when it crosses over into another state and affects interstate commerce, if it's concerned with more than one state, Gibbons versus Ogden says business concerned with more than one state falls under interstate commerce and thus is under the regulation of the Commerce Clause, i.e. the legislative branch, Congress, in the United States. Okay? Now, this began more and more with the railroad industry and then the airline industry later on after that and stuff like that in dealing with interstate commerce. Then on page 25 of your study guide, you have 3 cases that come into play. Now, Wicker versus Filburn's the main one, but you need to know all 3 of those. NLRB versus Jones and Laughlin, Wicker versus Filburn, and McLean, all are ways to further define interstate commerce under the Commerce Clause. NLRB versus Jones and Laughlin said anything that has a serious effect upon interstate commerce, Congress has the power to regulate. Wicker versus Filburn, Warrior Tier 1, says Congress can regulate what appears to be small, trivial acts if the combined aggregate effect is going to be nationally significant. And we'll talk about that when it comes to a couple of cases a little later on. But Wicker versus Filburn says small individual things that appear insignificant, that a cumulative effect has a national significance, Congress or the national government shall have the power to regulate. So, for instance, if you have a bunch of dairy farmers or wheat farmers or just agriculture in general or meat product industry, and you have certain farmers in Texas that are only selling within Texas, that is intra-state, within the state commerce, should be under the guidelines of Texas. However, because certain meats, certain poultry, certain dairy, certain agricultural crops are crossing over from state boundaries from some of these Texas farmers into, say, New Mexico, Colorado, Oklahoma, etc. Now it has a trivial act, the small little ones, individual farmers doing their own thing and not having to abide by national laws or not having to do anything that has a national thing is going to be against the rules or going to be against the law because it has a cumulative effect, aggregate cumulative effect on the national significance. Now we hit this a little later on with Smith versus Allwright and the Texas White Primary. We'll talk about that a little bit later on as well. Okay. So the result of these cases is the federal government can regulate business activity, one, if it crosses over state boundaries, because they already had that in general, and then if it has a serious effect or could affect commerce crossing over interstate lines, i.e. different states. And then obviously international, because it already has international as well. It opens the door for Congress to regulate business activity, even if it stays in state, if it could have affected or had some kind of effect on the national economy as well. Okay? The next thing under Commerce Clause is there are 3 issues dealing with states' rights, national government's rights in regards to the Commerce Clause and the 10th Amendment and its meaning and how it becomes important. The first one is McCulloch versus Maryland. Now, McCulloch versus Maryland was a case where the state of Maryland tried to tax a national branch of a United States banking system that was located specifically in Maryland. So if we add Maryland to that states list that we had earlier, Maryland, you had the Annapolis Convention that failed miserably, but they realized they didn't even have a majority. And then also we had McCulloch versus Maryland as well. The United States did not pay a tax to the state of Maryland that tried to tax it. Maryland sues for rights of those taxes. Now, the state of Maryland argued the 10th Amendment. Anything not expressly given to the federal government under these enumerated powers, Article 1, Section 8, shall be granted to the states. That's the 10th Amendment, which is a part of the Bill of Rights. The U.S. government argued necessary and proper clause, also known as the elastic clause, also known as the implied powers or inherent powers, and you can use those interchangeably. The necessary and proper clause, elastic clause, implied powers, and inherent powers is also the last clause in the enumerated powers. So it's also an enumerated power in Article 1, Section 8 as well. So not only do we have a dealing with the issue of Commerce Clause, we're dealing more with the issue of necessary and proper clause, or the elastic clause. And thus, the elastic clause is basically what gives the Constitution as a document its flexibility to operate over time, and gives, even though it doesn't grant specific more powers to the federal government, it covers any contingencies. And those contingencies have gotten bigger and bigger over time, thus wielding more power indirectly for the national government. In this case, the power to tax by the state of Maryland was found not to be legal because they found in favor of Maryland instead of McCulloch in this case. I'm sorry, they found in favor of McCulloch, who was a branch manager of this bank, instead of Maryland. Therefore, the necessary and proper clause in this case specifically trumped the 10th Amendment in regards to this taxation by the state. So therefore, in this first instance, national rights superseded that of states' rights. Okay? And you have all those examples, the necessary and proper clause examples on page 26, top of page 27, I guess. Oh, I'm sorry, 25, and then you also have the 26th page is the American Civil War. The American Civil War was fought over states' rights, obviously the right on how a state was going to be able to do intra within its state commerce. The main issue of that is slavery. The urban areas of the North weren't using slavery as much. The South was still agriculturally significant industry-wise, and therefore they were fighting over states' rights to have slavery in there. With the Civil War in effect, the North eventually won, obviously, and therefore the national government's rights trumped that over the states' rights when they tried to secede from the Union. The next one is the Civil Rights Movement. Now, in regards to the Civil Rights Movement, one of the main acts that you have is the Civil Rights Act of 1964. Now, we have Title VII in Chapter 12 that you need to go with workmen's, with employment compensation, employment benefits, all that stuff, and discrimination. But the Civil Rights Act of 64 is going to be the main thing. And a couple of the cases that are going to go about from it fall under this Civil Rights Movement in the Civil Rights Act of 1964. The first thing we had was the Jim Crow laws. The Jim Crow laws were a series of laws to keep former slaves, i.e. minorities, as second-class citizens. They are mostly found in the South, but not always. So you need to know for tests, they are also found in the North. And they're state laws rather than federal laws, because if they were federal laws, they would apply to all the states. So they're found in the North, but mainly in the South. Mostly in the South, but not always. There are very few always in this class. The first thing is Plessy versus Ferguson. Plessy versus Ferguson said the separate but equal doctrine was constitutionally allowed. Therefore, as a result of that, Jim Crow laws, treating people as minorities as second-class citizens, were legally allowed. And since these were done at the state levels, one of the things that the Texas state system did was it had its own, quote, white primary, which means it didn't allow people to vote at the primary election that didn't either hold land or were black or something like that, where only white people could vote in the primary. The problem is, when you have them only vote in the primary election, does that primary election have any kind of significance to the nationwide election later on? Well, if we're determining who's going to be the Republican representative during the general election and the Democratic representative of the general election, but we're only allowing whites to vote in this situation, then only whites determine the Republican and Democratic nominees. and in a heavily influenced state, either Democratic or Republican, then whoever wins the primary is going to win the general election. And way back then, we were heavily Democratic. Now we're heavily Republican. There's probably not going to be a Democratic electoral college or anything like that for years in Texas. But at the time, we were Democrat. So whoever won the Democratic primary was going to win in the Republican election way back with these Jim Crow laws in Texas and the Texas white primary. So it was going to affect, because now we don't care about the Republican nominee. We only care about the Democratic one, because that's who's going to win the general election. It'd be opposite of that nowadays. Okay. But because of that, the only election that had the only election that really stood for decision making in terms of voting and all that stuff was who was going to win the Democratic nomination at the time. Well, at that time, that was going to be only white owners or white people could vote, and therefore it was only a select group of people were allowed to vote for the Democratic nominee, and in that case, that's who's going to win. So these Jim Crow laws, Texas white primary laws, were found to be unconstitutional, but that wasn't until Smith versus Allwright. But these Jim Crow laws were separate facilities and stuff like that were slowly taken aback. Okay. President Truman integrated the military by executive order in 1948. I think we had that on the executive order sheet as well. Then you have Plessy versus Ferguson was in like 1896. 50, 60 years later, we have Brown versus Board of Education that overturns Plessy versus Ferguson and ends this idea of separate but equal doctrine being allowed. Is one of the defining moments of the civil rights movement. So Plessy versus Ferguson and Brown come alongside the civil rights movement in the 1960s, although this happened even 10 years before. Okay, the next thing you need to note, and then Brown versus Board of Education technically is not an example of judicial review. And that is because it's not the power of the courts to declare an action by the president or Congress as unconstitutional. It's when there's a logical and rational reason to change. Separate but equal under Plessy versus Ferguson. Common law stare decisis says we're going to change it when there's a logical and rational reason for doing so. They went ahead and did it here and made that overturn. Now, the civil rights movement in the 1960s passed the Civil Rights Act of 1964. Two main cases associated with the Civil Rights Act of 64. Katzenbach versus McClung, that was Ollie's Barbecue. Remember, they refused to serve food, only takeout window for those that were black. There's a dining room for white only. But since they bought certain amount of food from a supplier engaged in interstate commerce, they fell under that jurisdiction of what we talk about Wicker versus Filburn. Therefore, using that Wicker versus Filburn and the cumulative aggregate effect of that crossing over state boundaries, now the government can regulate and make them abide by the civil rights movements and the Civil Rights Act of 1964. Heart of Atlanta Motel, basically the same thing, dealing with rented rooms for interstate travelers, because those who are minorities would have to go outside the town, go into the colored section of town and find their own colored only motel or hotel. And that would affect interstate commerce because those wouldn't be in the areas that were close to the interstate. So both of those, Heart of Atlanta, Katzenbach versus McClung, also known as Ollie's Barbecue, were things that defined the civil rights movement by taking away the things that were going to be illegal activities and now making discrimination taken away from them in terms of this situation with restaurants and or hotels. All right, all the cases that we've talked about, with Plessy being overturned by Brown, Katzenbach, Heart of Atlanta, McCullough versus Maryland, Marbury versus Madison, all these cases have basically given more and more power to the federal government. But there was one limitation. Remember, the Constitution limits the power of the federal government, but we have all these contingencies and all this common law case law that says, oh no, we're going to limit the power, we're going to expand the power of the federal government. Here's one that limited the power of the Commerce Clause. U.S. versus Lopez, one of your tier ones. Lopez brought a gun onto the high school campus. This violated a congressional act, the Gun-Free School Zone Act, which made it illegal for anyone to knowingly possess a firearm in a school zone. He was convicted. The decision by the Supreme Court, in a very close decision, 5-4, said the Gun-Free School Zone Act was declared unconstitutional. So this is where the judicial branch declares an action by Congress declared illegal. That is an example of judicial review. It was very limited in scope. It was a very tight decision, 5-4 decision, and it was one of the cases that limited the power of the Commerce Clause rather than granting or expanding more power of the Commerce Clause to the national government. Okay, There's a couple other cases that are also examples on the next page. Prince, United States versus Morrison, Gonzalez versus Ray. But all of those I've heard, never heard about them, so they're more tier 3s. All right. The next thing we have is necessary and proper clause. We've already gone over that. Inherent powers and elastic clause and 5 powers. McCullough versus Maryland being the main case. Now remember, McCullough versus Maryland also dealt with commerce clause, but the more important thing that it did was necessary and proper clause, and you need to know that. It did not add to or subtract from the list of the enumerated powers, but it covered contingencies, and therefore it gave flexibility to the Constitution as a document to operate over a period of time. The next thing you have is a supremacy clause. The supremacy clause says the Constitution as a document is the supreme law of the land. Thus, the laws of the United States are superior to any state laws. And federal law in states, when they have concurrent power, if there's any interference or conflict with them, federal law reigns supreme. Now, the question is, can a state have the same law as a federal government? And they basically mimic one another. And there's absolutely no reason they can't. That is what we call concurrent power. When the states and the federal government are given the ability to create law in a certain area, both of them to cover the same subject at the same time, that's what we call concurrent power. The problem is when they are in conflict and they are interfering with one another. If, say, the state of Texas were to say the drinking age is 18 and the United States would say it is 21, there is a conflict and interference. Federal law reigns supreme. And until the state corrects it and makes their state law to be 21, maybe educational funds, highway funds are taken away. And this happened years ago, right when I was getting out of high school and stuff like that. They changed the legal drinking age from 18 to 21, like 6 months before I turned 21. Or I'm sorry, 6 months before I turned 18. So now I had an additional 3 years plus to do any legally drinking. But they were able to do this. Now the state of Louisiana decided they were going to keep their drinking age at 18. They lost education funds, highway funds until they made it up to 21 because federal law reigns supreme. Federal law not in conflict, federal law and state law in conflict with one another. Federal law is going to supersede that of state law. Now, what about areas in which the federal government chooses not to do anything about it, or there is conflict but they don't choose to do anything? For example, many states over the last few years have made marijuana use legal in their state under state law. However, we still have federal law that says marijuana use is illegal federally, except for exceptions medically and stuff like that. So now someone, say in Denver, Colorado, a state that allows marijuana use, gets busted, not by a state cop, not by anything like that, by state law, but gets busted for violating federal law by, say, a U.S. Marshal. That would still be illegal, even though Colorado allows it, it'd be illegal under federal law. But what the federal government is going to do is we're not going to mess with any of that stuff except for major drug trafficking and stuff like that. We're not going to worry about that. We're going to let the states dictate. And if more and more states go from the majority that don't allow it to be used to and then the minority of few states, if it looks like the evidence is showing that, hey, it can be used legally and it's not a problem, then maybe it'll become a more national law where marijuana use can be legal. So note that as well. Now, why would a state, if the United States makes a drinking age of, say, 21, why would the state of Texas mimic it by making a drinking age of 21 as well? If the federal law already reigns supreme, then hey, we already have the federal law. The way the states are going to be able to enforce it is to make a state law, and now they can enforce it. Because the federal government would enforce the federal laws, the states are going to enforce the state laws. Okay, so now the city police of whatever city or state or whatever can now make their own drinking law of 21 as long as it's no conflict, mimics it, concurrent power exists, everything's fine, there's no interference or conflict. Now they can make it, now they can enforce a state law as well. All right, but when they change the drinking age, then we have a problem. All right, then there's other areas where the national law has not been created, but if it affects interstate commerce, are we going to allow certain states to do certain things? And this is that Hughes versus Oakland, Maine versus Taylor on the bottom of page 20, or the middle of page 29, okay, of your study guide. Now in Maine versus Taylor, this is where Maine had a fishing industry that it wanted to protect. It had a legitimate state interest to protect its fishing industry, lobsters in reality, but all different fishing industry. And therefore they put a regulated bait. They said you could only use bait coming from a regulated bait shop in the state of Maine in order to do fishing in the state of Maine. Well, a person from Vermont or New Hampshire that comes over to Maine that brings their own bait in would be violating that state law. Okay? Well, that's crossing over state boundaries. Shouldn't the federal government have jurisdiction over that? Well, the problem is they said, the federal government said, we're not going to get involved in this. The state has a legitimate reason to protect its fishing industry. And since it didn't charge an exorbitant amount for this regulated bait, if they tried to charge 4 or 5 times as much, then yeah, the national government would have probably stepped in and said, no, this is illegal because it's affecting interstate commerce too much. But because they were trying to protect an industry and it wasn't expensive over the normal bait in New Hampshire or Vermont or something like that, they allowed it to occur. Oklahoma tried to pass similar laws, and it was found that they didn't have a legitimate state interest to protect the fishing industry. Thus, the regulated bait that they were trying to do was illegal in that situation, violated these interstate laws, whereas the Maine one didn't because there's a legitimate state interest. Note that as well for test questions also. All right. On the page 30, just understand we're going to talk about that syntax maybe a little later. Contracts fall under state law. That will be chapter 4 material. All right. The next thing we have are the Bill of Rights, the first 10 amendments associated with the Constitution. Now, originally the Bill of Rights only applied to limit the power of the national government. Once again, these are limitations on what they can do. It protects freedoms, rights, liberties, all that stuff, and it protects individuals as well as businesses. But it only applied to limit of the national government's rights. Barron versus Baltimore said that the Bill of Rights did not apply to the state governments, but only to the national government. Now, when we get to Gitlow, New York versus Gitlow case a little bit later on, Gitlow versus New York, in which he argued that he had a due process rights from New York under the 14th Amendment. We'll talk about that a little bit later, the 5th and 14th being the same thing. New York had to give him the same due process rights that the national government agreed and given him under freedom of speech and stuff like that. The Supreme Court agreed and created this doctrine of incorporation, where certain Bill of Rights applied not only to the federal government, but also to the state governments as well under a doctrine of incorporation. Now, the 14th Amendment gives this doctrine of incorporation, and the Gitlow case is what creates this doctrine of incorporation being born. And it gives rights under the Bill of Rights to apply to the states as well as to the federal government. So in Gitlow versus New York, Barron versus Baltimore was found to be illegal, and it was overturned. The Bill of Rights applied to not only national government, but also to that of the states. The Doctrine of Incorporation, the 14th Amendment, basically says the Bill of Rights, most of them, not all of them, the 3rd doesn't, the 5th and the 7th, parts of the 5th and 7th do not as well, but most, but not all of the Bill of Rights apply to the state governments as well. And this was a First Amendment freedom of speech issue with his manifesto in Gitlow's case, freedom of speech. So it argued doctrine of incorporation that it applied to the states as well. So when his due process rights were violated, it was found against the rules. All right, on page 32 of your study guide, only parts that do not apply to the states, the 3rd Amendment, because the quartering of soldiers doesn't apply, 5th Amendment, portion of the right to the grand jury, and then 7th Amendment, right of a jury trial in civil cases doesn't apply. States can make it to where it's not a jury trial in civil cases if they so choose. Okay, so the doctrine of reverse incorporation uses the 14th and 5th Amendments, and that's where something that was given specifically to the state governments under the 14th Amendment applies to the federal government under the 5th. And the 14th Amendment was expressly originally given to the state governments, okay, and not to the national government. But because of the doctrine of reverse incorporation, it applies to the federal governments as well under the 5th Amendment. So in a lot of areas, what applies to the national government is 5th, what applies to the state governments is 14th. And if it goes from the federal to the states, doctrine of incorporation. If it goes from the state to the federal, doctrine of reverse incorporation. And I'd note both of those as well. The main one here being Equal Protection Clause, we'll get to a little bit later on. All right. The next couple of things is freedom of speech, freedom of religion. I'm just going to go quickly over a few things that you need to know for this. There is no absolute right to freedom of speech. There is no absolute. There are certain limitations. You can't shout fire in a crowded theater. defamation of character lawsuits. You can't incite crime or revolution, obscenity, pornography, all would fall under their hate speech. All of those things are not going to give you absolute rights. And then on page 33 of your study guide, it gives you a bunch of cases. The only case I think I've seen on the exam before is Virginia v. Black. It's a tier 2. Virginia v. Black found that the burning of the cross in someone's yard by the Ku Klux Klan was hate speech, symbolic hate speech, violation of the First Amendment, and the Virginia law against hate speech was upheld or allowed to continue. And then Roth versus United States and the subsequent Miller versus California. In order to define obscenity, it's without redeeming social importance or lacks any serious artistic, political, scientific, or literary value. It's hard to understand. Basically, defined obscenity is something that I can't tell you exactly what it is, but I know when I see it. But in dealing with obscenity pornography, it falls under the Freedom of Speech, Amendment 1, and says it's going to be speech without redeeming social importance, and it's going to have no serious literary, artistic, political, or scientific value if you take Roth and Miller combined. I've heard Roth being on there as a tier 2, but Miller associated to it, just know the extras associated to that as well. On the rest of the stuff on page 34, haven't really heard about all that much. And then at the very bottom, we have commercial speech, which is advertising. Commercial speech is generally not protected. So we have political speech by an individual is mostly protected, most all, the highest level of protection. It's not absolute because of things that we can't do, like incite crime, revolution, like we talked about. Then we got to have business political speech, very little, minimal protection, but there is some protection. And that business political speech would be the idea behind it would be Citizens United versus Federal Election Commission, which overturned the Bipartisan Campaign Reform Act. So it's also an example of judicial review, and it upheld the rights under political speech by business under Citizens United on page 35 of your study guide. But for commercial speech is generally not protected. Thus, it can be regulated. And then it gives you a bunch of lists of cases. Haven't heard about any of those cases being on a swim exam, but just understand that the government can regulate commercial speech, but they must do it in the least restrictive means necessary. And they're going to err on the side of the individual, and they're going to look at the social interests of the whole town, state, nation in deciding it versus the individual. They're going to make a determination. Does the individual have freedom of speech rights, and how does that conflict with the balancing the interests of society as a whole? All right, so for test purpose questions that you need to know from these couple of pages, 33, 34, 35, you need to know, going all the way back to 31, Barron versus Baltimore and Gitlow are tier 2s. Virginia v. Black is a tier 2. Roth is a tier 2. Know the things associated to Miller. And then understand the freedom of speech, political speech, individual political speech being the highest but not absolute. Then you have business political speech, much lower at best minimal, but Citizens United, tier 2, giving us those standards. And then also you have commercial speech generally not protected at all, thus can be regulated. And there's a series of cases there that I haven't heard about being on a SWIMS exam at all. All right, that is through page 35. So now we're on 36, and we're talking about freedom of religion. Freedom of religion is also First Amendment. Are there absolutes? There are no absolutes in regards to religion other than one. There's what we call the free exercise clause. So we now have talked about the supremacy clause, the commerce clause, the necessary proper clause, implied powers clause, elastic clause, inherent powers clause, reserve powers clause, which is the 10th Amendment associated in the Constitution. Now we have the free exercise clause. The free exercise clause is a part of the First Amendment, so it's a part of the Bill of Rights. And it says you're free to believe anything in the name of religion. So the right to believe a religion under Cantwell versus Connecticut common law says the right to believe in a religion is absolute. The right to practice a religion is not absolute. So if you're a devil worshiper, the right to believe that religion or the religious undertones of devil worshiping is absolute. But if the practicing of the religion says we sacrifice a virgin every 6 months, then that would be basically murder. They're not going to be practicing the religion, would not be absolute. Okay? Now, the next thing is the Establishment Clause. And the Establishment Clause says the national government cannot establish a national religion. Now, when we talk about the national government not establishing a national religion, if you use that doctrine of incorporation, the Establishment Clause also applies to the state government. But it was expressly given federal government, national government cannot establish a national religion. But because of the doctrine of incorporation, the idea, it also applies to states. So the state governments cannot establish a state religion. Okay? So that is what the Establishment Clause says. Also part of the freedom of religion under the First Amendment of the Constitution. So in that, you have a bunch of cases, County of Allegheny, Van Orden, McCreary County. These were all where the government entity at the state level endorsed, if they did or did not endorse a specific religion. If you did a religious theme that didn't have any non-specific denomination, so it was non-denominational, then it's probably going to be okay because you were not endorsing a specific religion. However, if you have much more of a scene or a monument or something like that that endorses a more specific religion, these are probably not going to be allowed. One, at the federal government because of the Establishment Clause, but also because of the Doctrine of Incorporation and the Establishment Clause applying to the states as well. A state building could. So if you have a state building, a governmental building that has a bunch of monuments associated with Christianity or Judaism or something like that, those would be endorsing a specific religion. Those are likely not going to be allowed. You cannot endorse a specific religion. You cannot establish an official religion. You cannot endorse a specific religion. And you cannot have religious items that would be denominational rather than non-denominational on site. Okay? The next thing that you have is blue laws and Sunday laws. Blue laws are Sunday laws, and don't get those confused with the blue sky laws in chapter 10, Kansas wheat fields. But blue laws are Sunday laws, mainly found in the South, but also in the North, mostly in the Bible Belt, Texas being the Bible Belt state, require businesses to either not sell or be closed or only partially closed or totally closed on a Sunday for a uniform day of rest. Obvious religious undertones, but constitutionally wise, it's for a uniform day of rest. So certain businesses would have to be either closed or partial closure of those businesses in the Bible Belt, mainly the Bible Belt, although all over. Some businesses have to be closed because of blue laws or Sunday laws. Okay, so note that. There is a separation of church and state according to Thomas Jefferson. There's never been that standard technically, although we talk about separation of church and state all the time. All right. On page 38 of the study guide, you have the Fourth Amendment. The Fourth Amendment deals with unreasonable search and seizure without a warrant. If you have no probable cause or no warrant or an unreasonable or illegal search and seizure, this would be a Fourth Amendment violation, regardless of state or federal. It is a Fourth Amendment violation. Now, we'll get into another storyline in a little while about what amendments could apply. Therefore, there are going to be specific situations where there's not going to be a need for a warrant if probable cause exists. Say, for instance, someone pulls you over for speeding. They now have probable cause if they smell marijuana on your breath or something like that when they get a ticket or smell alcohol, to probable cause to look because they have probable cause to pull you over with a speeding violation, and now they smell alcohol or smell marijuana. They can continue on through that without having a warrant because probable cause exists. If they didn't have any probable cause, then they would likely need a warrant. Now, remember the warrants in chapter 12 when it comes to OSHA and stuff like that. A warrant, administrative warrant, don't make them get one because they'll just come back mad. Note that for the test as well. All right. Now, there are certain times when a warrant is not needed if it's an open field situation, stuff like that, because no one has an expectation of open field of expectation of privacy in an open field. Therefore, open field doctrines do not require a warrant. Okay. But if it gives you a storyline and uses the warrantless search and seizure or illegal search and seizure or unreasonable search and seizure, okay, or lacks probable cause, then any evidence obtained is the fruit of the poisonous tree and thus more than likely illegal. Now, obviously, automobile searches have a higher level and stuff like that. And then if there was probable cause or they did have a warrant, that all would be admissible. But if they don't have it, it's what we call the exclusionary rule. The exclusionary rule follows in the Fourth Amendment, illegal search and seizure, and says certain evidence obtained during an illegal search and seizure, unreasonable search and seizure, a warrantless search when a warrant is needed, a lack of probable cause exists. When that occurred, then all that is fruit of the poisonous tree and cannot be used. Now, that is the evidentiary exclusionary rule when it comes to the Fourth Amendment. There are 4 cases: Brigham City, Hudson, Georgia, and Illinois. You might want to note those are collective. I don't know about those being on the exam, but it chipped away from this fruit of the poisonous tree in certain instances. So it's not always going to be illegal or not always going to be excluded, just so you know that. All right. We're going to come back to the Fifth Amendment when it comes to self-incrimination. But remember, self-incrimination under the Fifth Amendment applies only to individuals and only in criminal cases. Okay, the Miranda versus Arizona gives you your due process rights when it comes to self-incrimination doctrine and stuff like that. But remember, Fifth Amendment gives us protection against self-incrimination. It applies only to individuals, not businesses, and applies in criminal but not civil cases. And we did that with the chart in earlier in one of the videos. All right. The next thing we have is the due process rights. Due process. The government cannot deprive an individual of life, liberty, or property without due process of law. Does that mean the government can take away your life? Yes, execution. Can they take away your liberty? Yes, put you in prison. Can they take away your property? Yes, eminent domain. They can do all of these things, but they must follow due process of law. When they do that, the national government is the Fifth Amendment. The state government is the 14th Amendment due to doctrine of incorporation. So this due process, eminent domain, falls under the doctrine of incorporation, where it applies to state governments that are originally expressly Barron versus Baltimore saying only the national government. Now, due process is not specifically defined within the Constitution at all, and it's going to use a sliding scale. We'll talk about that sliding scale maybe a bit later. All right. On page 40 of your study guide, you have eminent domain. Eminent domain at the federal level would be the Fifth Amendment. So if the federal government takes away your land for use, it'd be the Fifth Amendment. If the state of Texas was to take away your land, it would be the 14th Amendment. So it depends on, is it a state action to take away your property, or is it the federal government? Regardless, they must give you just compensation. Now, just compensation does not necessarily equal fair market, although it could. So if fair market is $200,000 and they give you $200,000, then that is going to be fair market value, but it also includes just compensation. If just compensation to the government is only $200,000, but you could have gotten $225,000 on the open market, then just compensation would be $200,000, not the $225,000. Okay. Now there are some safeguards. Remember, there are no safeguards. There are no safeguards with the Endangered Species Act. They can take away your land without any compensation at all. That's from Chapter 14 as well. So under eminent domain, if the government takes away your land, storyline scenario, if the government takes away your land, was this federal government or state government? Because that's going to apply on which amendment, the 5th for federal, 14th for state. If they take away your land, do they have to give you fair market value? No. Can they give you fair market value? Yes, that would then equal just compensation. But they must give you just compensation. It does not equate or have to be fair market value. All right. The last couple of things from Chapter 2 that we need to note is the Equal Protection Clause and a right of privacy. And the Equal Protection Clause is under the 14th Amendment. This was specifically reserved to the states, but applies to the national government under doctrine of reverse incorporation. So anything about equal protection is the 14th Amendment in a state action, 5th Amendment in a federal action. Okay? It applied directly to the states, applies to the national government due to the Fifth Amendment doctrine of reverse incorporation. The government can treat people differently as long as there's a logical and rational reason to treat people differently. 21 and over, 18 and over for voting and stuff like that. These are all ways that you're able to treat people differently. And if you think about it in terms of Chapter 3, we can say you must be at least a certain age to be a federal, state judge in the state of Texas in certain court systems. This would be Equal Protection Clause being used, the 14th Amendment at the state level. So we have to ask ourselves in this Equal Protection Clause, is the government, which government's doing this to you? If you know it's the federal government that's treating people differently based on a logical and rational reason, i.e. the federal government has a drinking age of 21 plus, then that is going to be the Fifth Amendment of the Constitution. If the state of Texas mimics that law, because of concurrent power, interference, all that stuff, but they mimic it by saying 21 up. The state of Texas can make that based upon the 14th Amendment, equal protection at the state level. Treat people differently based on logical and rational reason. Now, there's difference. Federal law reigns supreme because that's the supremacy clause that you have. All right? But equal protection, treating people differently based on a logical and rational reason for doing so. So if the government treats you differently based on a logical and rational reason, what amendment is it? Well, it depends on which government. It could be depending on which court you go to, but it could be depending on which government as well. So if it's the federal government, it's the 5th. If it's the state government, it's the 14th. If he doesn't tell you which government, and this is what we talked about in exam 1, if you came for exam 1, that you might have been a little lost on if you didn't come for tutoring, is it's 5th or 14th, not 5th and 14th. It's going to be one or the other. So the better answer is 5th or 14th, not 5th and 14th, unless you know specifically it's both the federal and state government that's doing it to you. If you don't know which government it is, or you don't know which court you're going to, federal or state, then it's 5th or 14th. So B or C might be the option instead of B and C. All right. When it comes to the Equal Protection Clause, there's a 3-tiered sliding scale. And you should have a page in your packet somewhere around the exam 1 material that's called amendments. And towards the very bottom, we have the lowest level of protection. Okay? The lowest level of protection is called rational basis test. Rational basis test. And it concerns itself with economic, so it deals with economic and social values, clauses. It's rarely overturned because you're going to put a mathematical model associated to it. So for the lowest level of protection under the Equal Protection Clause, you have rational basis test is what it's called. It deals with social or economic clauses. The intermediate level of protection is substantial governmental interest. It's called substantial governmental interest. It deals with gender or the legitimacy of a government action. We talked about that with the fishing bait and stuff like that. That would be substantial governmental interest. The highest level of protection is called compelling state interest. Compelling state interest. And that deals with your fundamental rights being taken away from you, or suspect classification on page 41. That would be more race, color issues. All right? So note those 3 things there. Now, on the other chart off to the left of that on your page, let me try to get you to where you can see that page. Okay? You have under freedom of religion, federal is 1, state is 1. Illegal search and seizure, federal is 4, state is 4. Self-incrimination, federal is 5, state is 5. Then it's going to be different for the next 3. Due process is 5th. You want to put a circle around that because it expressly was given to the federal government under the Bill of Rights. And then because doctrine of incorporation, it applies to the states under the 14th Amendment. So you might want to put a little arrow there. Eminent domain, 5th for federal government, because that's just a part of due process. 14th Amendment for state, arrow because of doctrine of incorporation. Equal protection, federal is 5th, state is 14th, but you want to put the arrow going from state to federal. That's doctrine of reverse incorporation based upon the Equal Protection Clause. All right. The right of privacy, the last thing we have on page 41, 42 of your study guide for chapter 2, and then we'll be done, is not specifically recognized by the Constitution. It would be one of the major fundamental rights, so we're talking about that highest level of protection, compelling state interest above. But the cases associated to it would be Roe versus Wade, Griswold versus Connecticut, and Lawrence v. Texas. All 3 of those on page 41 of your study guide. Someone said Griswold versus Connecticut was on their exam. That would be one of the first times I've heard. Someone else said it in a summer, I thought, but they weren't sure, so I've never really done. Griswold versus Connecticut was a right to privacy case, common law issue that said the law violated the right of marital privacy. In terms of the law, Connecticut had a statutory law at the state level, so note that as well. Then also certain statutory laws are dealing with right of privacy, Freedom of Information Act, Privacy Act, HIPAA laws, Patriot Act, all fall under there as well. So you have not only common law for the right of privacy, but also statutory law as well. So it's a combination of statutory and common law. Roe versus Wade being a big Texas case there. Lawrence v. Texas also. Remember, don't get Lawrence v. Texas confused with Texas v. Johnson, the flag burning case associated earlier in chapter 2. All right, that's it for chapter 2. I think most of the questions in chapter 2 are fairly self-explanatory in the back. In fact, I say some of the older ones are better than these. Yeah, I think all of these are way too easy in chapter 2. But anyway, if you have any questions, the next thing we're going to do is chapter 3. I'm going to do just one video on the chart. If you look at the chart on the very back of this packet, I think it is, this is the court system chart. We're going to do one video on the court system chart and compare it to the federal system. So we're going to fill in this chart. If you came for exam 1, you completely bypass this video if you want, because you have all the material there, or you can use it as a refresher. We're going to do the exact same video, or we're going to do the exact same chart. So if you already have this filled out, the next video on chapter 3, court systems, you don't need to do maybe the last few minutes of it when we talk about compare and contrast the state versus federal. We've already done the beginning of chapter 3 with the civil versus criminal when we made that chart in the earlier video. All right, this will end this video, and we'll start with the court systems of Texas in the next video.